Chapter 18. Religious Liberty. Too often, religious toleration is seen by historians as a beneficent goal in history, by which they mean that various states in Europe ceased to persecute Protestants or Catholics. Thus, tolerance succeeded intolerance. Superficially, there is a limited measure of truth to this. After 1660 in Europe, religious intolerance began to wane. As early as 1598, with the Edict of Nantes, France granted religious toleration to the Huguenots after much bloodshed. Poland came to a like settlement without the same conflicts. However, the fallacy in this popular view of the growth of wisdom in the form of toleration is that this toleration was not based on a belief in freedom, but a growing indifference to Christianity. Instead of the Church, the state was now central to life, and the state now silenced dissent concerning itself. The Western world was in process of shifting its intellectual foundations from Christianity to humanism, and as a result, the locale of intolerance shifted. There is no toleration, for example, in state schools and universities for avowed creationists, and their persecution and elimination are justified on the basis of sound scholarship. In Marxist countries, which are more consistently humanistic, such open dissent leads to slave labor camps. Toleration and establishment thus continued their sway. At the same time, the more important the state became, the more trifling and subservient the established church became. The American colonies began with some quasi-establishments. Technically, the Church of England held the right of establishment in all of them. In practice, each colony, or in some cases local areas therein, had its own establishment, settlement, or liberty. Bridenbaugh in Mitre and Sceptre has shown that the prospect of bishops being sent to the colonies with a rigorous establishment to follow contributed greatly to the break with the Crown and the War of Independence. This threat led to more than a little rethinking of the subject in the colonies. At the same time, the Baptist leader, Isaac Backus, did much to further the doctrine of religious freedom. A major consequence of this was the First Amendment to the U.S. Constitution. Quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. End quote. The clergy of the colonies strongly favoured this amendment. The establishment toleration pattern was also being recognised as a dangerous one, although it lingered in Massachusetts for some time. While an established church clearly could be powerful, it was at the same time subservient to the state in most, if not all, cases. There were two other serious problems with an established church. It was both a silent church and a more readily corrupt church. For most of the history of the United States, the First Amendment and its restraint was applicable only to the federal government, not to the states. In recent years, using the 14th Amendment as justification, the U.S. Supreme Court has, in the name of no establishment, struck down such things as public school prayers. The First Amendment in itself has simply two emphases. First, there can be no establishment of religion. For the framers, this meant no establishment of a church or of a specific pattern of doctrine, such as Calvinistic or Arminian. Since there were no other religions of any significance to consider, what was in mind was the exclusion of the possibility of any church becoming the federally established church. When the Internal Revenue Service takes upon itself, as it does today, the power to determine which religious groups shall be tax-exempt, it is establishing a church or a religion. Until recently, a church was a church simply because it was one, not because the IRS said so. Second, Congress is barred, the federal government barred, from any interference with the free exercise of religion. This provision specifies that the freedom belongs to the Church and to all forms of the free exercise thereof, in societies for religious purposes, public exercises, and so on. Since the Constitution was intended to be a document of explicit powers only, all powers not specifically granted therein were barred to the federal government. The framers thus saw no need for the First Amendment. A limited federal government had no jurisdiction whatsoever in the sphere of the churches. However, the sentiment was so strong for an explicit assurance of the areas of immunity from state control that the Bill of Rights was passed. Some scholars have felt that it would have been better had no Bill of Rights been passed, since the doctrine of explicit powers only would have meant that the federal government has no jurisdiction except where specified by the Constitution. However, the Constitution gives no powers to the federal government over education, medicine, welfare, and much else, all fields into which the federal government has intruded. No law is a sufficient safeguard against a change of faith and character. Every law system is an enactment and an establishment of religion. Law is inescapably moral. It sets forth ideas or concepts of what is evil and forbidden and what is good and permitted. Law reflects thus a religious world and life view. To change the nature of a legal system means to change religions. Law, by nature, cannot be morally neutral because it condemns certain forms of behavior and protects others. This fact was known to the framers of the Constitution because statute law was then uncommon as compared to the use of the common law. Common law, as Rosenstock-Huessy pointed out, quote, did not claim a national origin, but was the diary of Christian baptism, end quote. The common law included some elements of Roman law, but it was essentially biblical and ecclesiastical law. When we turn to the Young Republic, we find that the common law had this meaning. Even Thomas Jefferson recognized this fact. Quote, in the principle that Christianity was part of the common law, Jefferson saw the transmitting of the maxim from English to American shores as the transplanting of the seeds of establishment, end quote. Precisely. Jefferson did not want a biblical foundation, but an Enlightenment one. Some kind of establishment is inescapable. On the U.S. Supreme Court level, in the early years, Justice Joseph Story was emphatic that Christianity and the common law were the foundations of the Union, liberty, and social order. Story saw Jefferson's attack on the place of Christianity as part of the common law, as indicative of disloyalty to the Union and an intellectually untenable position. It should be noted that Story was a Unitarian leader, politically a Democrat and a moderate liberal, not a champion of the old orthodoxy. In England in 1676, Justice Matthew Hale had summed up the matter of the common law thus, quote, the Christian religion is a part of the law itself, end quote. Kent, in his commentaries, spoke eloquently of the common law as the fabric of life. He cited de Ponceau's moving words, quote, we live in the midst of the common law. We inhale it at every breath, imbibe it at every pore. We meet with it when we wake and when we lie down to sleep, when we travel and when we stay home. And it is interwoven with the very idiom that we speak, and we cannot learn another system of laws without learning at the same time another language, end quote. Because of the religious nature of law and society, men like Story could accept and defend an institutional separation of church and state while recognizing, in McClellan's words, quote, at bottom, church and state are forever united, their total separation impossible, end quote. No preference should be given to any particular quote-unquote sect or denomination, Story held, but neutrality with respect to religion is impossible. Christianity, he believed, should be supported by the state, not with funds nor by forcing any man's conscience, but by recognizing it as the foundation of law and social order. Laws against blasphemy, Sabbath laws, and the like were for Story a part of this support. Not until 1947 and 1952 did the US Supreme Court move openly towards disestablishing Christianity and establishing humanism as the foundation of American life. Story, in his Commentaries on the Constitution of the United States, Volume 2, 591, 2nd edition, summarized the matter thus, and the courts concurred for a century and a half. Quote, "The real object of the First Amendment was not to countenance, much less to advance Mohammedanism or Judaism or infidelity by prostrating Christianity, but to exclude all rivalry among Christian sects and to prevent any national ecclesiastical establishment which would give to a hierarchy the exclusive patronage of the national governments. It thus cut off the means of religious persecution, the vice and pest of former ages, and of the subversion of the rights of conscience in the matters of religion, which had been trampled upon almost from the days of the apostles to the present age." End quote. Cord cites three other purposes of the First Amendment. First, a limitation was placed on the powers of the federal government, denying it the prerogative of establishing a national church or religion. Second, the federal government was barred from encroachments on the freedom of conscience. Third, the First Amendment left the relationship of church and state under the control of the individual states. This last restraint both recognized the matter as within the jurisdiction of the states and at the same time left alone the local establishments and or arrangements existing in the various states. It should be noted that the free exercise of religion was seen by the courts for generations in terms of common law Christianity. Reynolds versus the United States dealt with Mormon polygamy. Reynolds felt that his First Amendment rights had been violated by the prohibition of polygamy. The U.S. Supreme Court ruled against Reynolds. It saw that virtually every crime is somewhere practiced by a religious group. Among the aspects of some religions are or have been human sacrifice, cannibalism, ritual prostitution, bestiality, murder, homosexuality, and more. Absolute freedom of conscience and religious practice would destroy all law and social order and would make civil government impossible. Such a view of religious liberty, said Chief Justice Morrison Waite, 1879, would, quote, "in effect permit every citizen to become a law unto himself. Governments could exist only in name under such circumstances." End quote. We can thus say that religious liberty is within the context of a particular religious and moral tradition. Absolute religious freedom means the total license to practice every kind of crime and perversion. A law structure embodies a moral code and an implicit religion. The freedom it gives is within the boundaries of that religion. It cannot allow practices which are criminal in terms of its presupposition. However, the American settlements does not permit that any particular church be granted a privileged status by the federal government, nor that any particular theology be preferred. Common law Christianity means that the law structure of the country is biblical, not Buddhist, Mohammedan, nor anything else. There can be no separation of religion and the state. The question is simply, which religion will undergird law and society?